Tevin Collier. All right.
And he's actually in the courtroom right now.
Is he here in person?
He's on Zoom already.
Oh, okay, yeah. All right. Anyone else need to check in?
Yep. Good morning. This is Attorney Curry checking in on Stacy Johnson.
All right. All right, she's in the waiting room. I'll let her in. All right, anyone else need to check in that's not checked in?
Yes, good morning. Attorney Sydney Henderson checking in on behalf of Tevin Collier.
I think that's been retained out, Counselor.
Okay, I'll go ahead. Oh, thank you.
Yeah, he's yep.
Have a good day.
Anyone else? Anyone else need to check in that has not checked in?
Stacy Johnson.
I have you checked in, Ms. Johnson, okay?
Okay, thank you.
Your attorney is on. Anyone else need to check in that has not checked in?
I would like to check in for Earl Leonard. It's a PCC, and if I could waive his presence, that'd be great.
I'd like to check in for Reginald Coleman.
Reginald Coleman. All right, I got you checked in, Mr. Glenn. Thank you. Anyone else need to check in that has not checked in? I thought I admitted Attorney Lyons. DeAndre Jones. Attorney. I was trying to get it straight. Yeah, Attorney Lyons.
Good morning.
All right, there you go. Good morning. I have you checked in, okay? Your client is on also.
Thank you, ma'am.
Reginald Coleman. All right.
36th District Court, City of Detroit, State of Michigan, is now in session with the Honorable Judge Ronald Giles presiding. You may be seated.
All right. Ready, Kim?
I am.
Calling case number 2159299, the people of the state of Michigan versus Hannibal Fuquan-Bay. Defendant is charged with count 1 and count 2. Police officer assaulting, resisting, obstructing, habitual offender, second notice. This matter is scheduled for a probable cause conference.
Bill Henderson for the people, P86029.
Good morning, Judge. Robert Kinney appearing on behalf of Mr. Fuqua-Bay. I've been talking to him since about 7:30 this morning, but I don't know how to get him to put his name on there. If you let me waive his presence, he's out in the waiting room.
All right, waive his appearance for the purpose of this hearing.
Thank you, Judge. I got paper discovery. If there's any videos, I'd like to have them, and I want a preliminary exam date.
All right, you need to make sure you send in an order for the discovery. I can act on that if you don't get it. You're available June 5th at 9:30?
No, not June the 5th. It's June the 8th at 9:30?
All right,
June 8th, okay?
yeah, June 8th, 9:30.
Okay. Can I speak to bond judge? The May I speak to bond?
Hold on.
Okay.
Go ahead.
Judge, I want to modify that tether. They got them paying $40 a week.
I beg your
And
pardon?
they want him to pay $40 a week is what they told me. And he's trying to get his tickets taken care of. Is there any way that we can either modify that so that he can continue his employment? He's on 24-hour call with a tow
Problem is,
truck.
you know, put him on, he didn't show up last time. We had an exam set, he didn't appear.
He had an exam set. Okay. I just got this case. You mean it was up prior?
Yeah.
Okay.
The
How about,
the curfew is from 10 PM to 6 PM. So how does that stop him from working?
10 PM to 6 PM?
Yeah, no, 10 PM to 6 AM, excuse me.
10 PM to 6 AM. Well, he tells me that he works with he is a rolling mechanic that works with the tow trucks. Is what he tells me.
He's on now. Mr. Fukambe is on.
Can you guys hear me?
Yes, we
Yes,
hear
you
you.
Okay, I'm not gonna just leave it open. You know,
Okay.
You know, we went through the thing, he didn't show up last time.
Yes, sir.
He wants to provide, you know, his hours. You know, I don't know, what I'm not quite sure what
Green
that
after
means.
that, you put the Zoom ID number up top.
Ms. Grady, put your system on mute, please. You know, I don't know if you're saying he gets a call and goes out, or he works certain hours, I don't know. You know.
Yeah, he gets a call. He gets a call and he goes out.
Excuse me, am I able to talk so I can explain it a little more?
No,
Okay.
no, you're not. Please don't say anything. Give me 1 second.
Yes, sir.
Let me ask you this, does your client have a driver's license?
He's trying to get that, Judge. He's paying off the tickets to get his driver's
Well,
license.
see, that's the problem, Mr. Kenny, he's trying to get it, but he keeps driving, and if he's getting calls in the middle of the night, then he's going out driving on, for that. I can't support that.
No,
I don't
No,
think he's,
no, Kwame, don't say anything. I don't know how much clearer I can make that.
Judge, he tells me that he's having someone drop him off where the tow truck is. Then he rides with the tow truck. So he's not driving. And he's working with a company out of 36th District, he tells me, that's helping him to pay his tickets. He's got to pay reinstatement fees, but they're doing what they can to help young men get their license.
All right, I'll remove the teller. But Mr. Kwame, I want to make this real clear. You get a ticket and I find out, I'm not only gonna slap a tether back on you, but I'll do a lot more. Do you understand that? Do
Yes,
not
sir.
drive. All right,
You hear
Mr.
that,
Kenny, I need
Mr.
an order.
Thank you, Judge.
I'm gonna need an order, Mr. Kenny.
Yes, sir. I get it today.
All right. Okay.
Calling case number 2356984, the people of the state of Michigan versus Tevin Collier. Defendant is charged with count 1, impersonating a peace officer to commit a crime. Count 2, count 3, count 4, check, non-sufficient funds, $500 or more. This matter is scheduled for a probable cause.
Philip Henderson on behalf of the people, Your Honor, P86029.
And good morning, Your Honor. Brent Leader on behalf of Tevin Collier, P70866. Mr. Collier is present via Zoom, and we have no objection to proceeding in this manner.
Mr. Collier, can you state your name for the record, please?
Tevin Collier.
Thank you, sir. All right, what's your pleasure, counsel?
Your Honor, this is set for a probable cause conference. I was just retained on this matter. I'll send in a discovery order, but we just like an exam date at this time.
You available June 10th at 9:30?
June 10th? I have that as a Saturday, Judge.
June 5th.
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 Could we do the 7th? Is that possible? That Wednesday?
June 7th at 9 o'clock?
9 o'clock would be fine.
All right, anything else?
Nothing more, Your Honor.
All right. See you back then. Thank you.
Thank you.
Closing hearing.
Calling case number 2356913, the people of the state of Michigan versus Stacy Johnson. Defendant is charged with count 1, weapons carrying concealed, count 2, weapons dangerous weapon, miscellaneous. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, Your Honor, P 86029.
And good morning, may it please this honorable court, Sophia Curry, P 72103, appearing on behalf of Stacy Johnson, who is also present via Zoom. Ms. Johnson, please state your first and last name for the record.
Stacy Johnson.
Ms. Johnson, you guys find a place and stay still, please.
Sorry, I just walked into work.
Okay, thank you. Go ahead, Ms. Curry.
Your Honor, I have paper discovery. I do not have any digital, and there should be body cam footage that's indicated in the police report, as well as dash cam video. So I do have a discovery order prepared that I'll send over to the court, and we're just asking for an exam date. I cannot do the 5th or the 6th.
Mr. Curry, I have requested the digital from the officer. I'll get it to you as soon as they get it to me.
Okay, it's just so you know, it's Michigan State Police.
Right, that should be today. I'm in contact with them.
Okay, thank you.
June 7th at 9:15.
The 7th at 9:15 will work, Your Honor.
Thank you. Anything else?
No, thank you so much.
All right, thank you. Closing
You can
hearing.
log off, Ms. Johnson.
Thank you. Can you, text me or something?
Mm-hmm.
Okay, thanks.
Okay.
Calling case number 2356761, the people of the state of Michigan versus Earl Leonard. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
On behalf of the people, Philip Henderson, P 86029.
Veronica Walrad with NDS. Veronica Walrad with NDS P 85665 on behalf of Mr. Earl Leonard, who's present via Zoom. Mr. Leonard, if you could unmute yourself and state your name for the record.
Earl Leonard.
Thank you. I believe that discovery is complete in this case, so we are just asking for an exam date.
Are you available June 5th at 9:30?
Yes, Your Honor.
Anything else?
No, Your Honor. Thank you.
All right. That concludes the
Mr.
hearing.
Leonard,
Thank
you're
you.
free to leave.
Okay.
Calling case number 2356965, the people of the state of Michigan versus Reginald Coleman. Defendant is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony, firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony, firearm, habitual offender, for notice. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, P 86029.
William Glenn, P36794 on behalf of Mr. Coleman. Mr. Coleman, can you state your name?
Reginald Coleman.
All right, Mr. Coleman, so you know in the future, I don't do T-shirts in my courtroom. T-shirts or sweats, that includes on Zoom. So when you come to court, please wear a shirt with a collar.
I
All right?
apologize, sir, but I'm at work.
I understand you at work, but you're also in my courtroom.
Okay.
Okay, so just when you come back, just please a shirt with a collar.
I apologize. Okay.
That's all right, thank you.
Your Honor,
All
we're
right.
asking for an exam date, Your Honor.
You're available June 5th at 10 o'clock?
Yes, Your Honor.
All right, anything else?
No, Your Honor.
All right, thank you. That concludes the hearing.
Okay, Mr. Coleman, you can log off. I'll be in touch with you.
Please do. Have a good one.
Take care now.
Calling case number 2356998, the people of the state of Michigan versus DeAndre Jones.
Good morning, Your Honor. May it please the court.
Hold on, I'm sorry. Hold on. The people of the state of Michigan versus DeAndre Jones. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, police officer fleeing third-degree vehicle code. This matter is scheduled for a probable cause conference.
For the people, Philip Henderson, P 86029.
May it please the court, George Lyons, on behalf of Mr. Jones. Mr. Jones, would you please identify yourself?
Leandre Jones.
Your Honor, if I may.
Yes, sir.
I'm in possession of the paper discovery as well as some digital. It's scheduled for a June 7th preliminary exam date. We wish to have an exam, but counsel is not available on the 7th, Your Honor. Is it possible to reschedule that date?
Yeah. Hold on a second. You're available June 6th at 10 o'clock?
June 6th, Your Honor. I believe I can make that work.
Okay.
Thank you, Your Honor.
All right. Thank you.
All right. Thank you. All right.
Anything further?
No, I'm satisfied, Your Honor. Leandre, you can log off. Thank you, Judge.
Thank you.
Calling case number 2356991, the people of the state of Michigan versus Gregory Poole. Defendant is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing, count 3, weapons felony firearms. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, P 86029.
And good morning, Your Honor. Robert Cantor, P 24993, appearing on behalf of Gregory Poole, who is present via Zoom. Mr. Poole, can you state your name?
Gregory Poole.
Mr. Poole,
Gregory Poole.
do you have video? You need to turn on your video, please.
Can you hear me, sir?
Yes, sir. Thank you. All right. Asking for an exam date, counsel?
Yes, Your Honor. I have received the discovery and we're just requesting an exam date.
June 7th at 9:30.
That would work. And Your Honor, if I may ask about bond, my client tells me he got a new job that requires him to work between the hours of 11 a.m. to 11 p.m. Right now, his tethered hours are from 7 a.m. to 7 p.m. And we would ask that, if possible, that the hours that he's out on tether could be adjusted.
You have to provide proof that he is in fact working. And he's working those hours.
Very good. I'll see what I can do, Your Honor, as far as getting that proof.
Okay.
So when do I have to show that, sir?
If you can get that to me today, Mr. Poole, any proof that of your employment hours, then I can forward that to the court with the proposed order.
Okay, so you just need document of my employment, right?
Correct.
In your
And
hours.
the hours.
Okay. I'll get that document to you by no later than 6 o'clock.
Okay.
Is that fine?
Yeah, that's fine. Whatever you can do. And thank you, Your Honor. We'll see you on June the 7th.
Okay, well, thank you.
Yep.
All right, thank you, sir.
You're welcome.
We're done.
Yeah, we're done.
Calling case number 2356468, the people of the state of Michigan versus Jamari Travis. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, P 86029.
And good morning, Neighborhood Defender Service by Kate DeMott Grady, P 83667, on behalf of Mr. Jamari Travis, who is on Zoom. Mr. Travis, can you please unmute yourself and start your camera and state your name for the court?
Jamari Travis.
Thank you.
Your Honor, I've received both paper and digital, and I'm requesting a preliminary examination date.
June 7th at 10 o'clock.
Your Honor, I'm starting an armed robbery trial that morning before Judge Anderson at Frank Murphy. So is the court available? I guess my trial is anticipated to go those 3 days. So I could either do the 6th or I could do the 12th.
June 6th at 10:45.
That works for me.
All right. Anything else?
Nothing else from defense. Thank you.
I conclude the hearing. Thank you.
Thank you. Mr. Travis, you can sign off.
All right. Have a nice
Thank
day.
you. You too.
Anyone else need to check in that has not checked in?
Yes, this is Attorney Alexandra Cho. I am here on Michael Morello, who I believe is in the waiting room.
That should be in 439. That's Judge Jefferson.
That is Judge. Okay, well, thank you so much.
You're welcome. All right, so we got, Wayne County Jail, are you Mr. Turner? DeQuan Turner?
Yes.
All right, we're just waiting on your attorney, okay?
Okay.
Oh, and here he is. Good morning.
Hi, good morning.
You ready?
Yes, Dominique Turner. It's gonna be a waiver.
Yep.
Daquan Turner. Dominique Turner.
I'm sorry. Did I
gotta-
say Dominique? I'm sorry. I said DeQuan. I'm sorry, DeQuan. Yeah, I'm sorry. It's DeQuan Turner. Yes.
Okay. Calling case number 2356994, the people of the state of Michigan versus DeQuan Turner. Defendant is charged with count 1, breaking and entering a building with intent. Count 2, weapons carrying concealed. Count 3, weapons felony firearm. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, P86029.
And good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of DeQuan Cortez Turner. He's appearing by way of video conferencing from the Wayne County Jail. And we're here for a probable cause conference, Judge.
All right. You asking for an exam date or what?
Oh, I'm sorry, Judge. Yeah. No, Mr. Turner and I met yesterday. We reviewed the discovery, and he's elected to waive his statutory right to a preliminary exam, knowing he will be bound over to the Wayne County Circuit Court.
We have no objection to that, Your Honor.
All right, Mr. Turner, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Sure.
Anybody promise you anything? Well, you didn't hear, I couldn't hear your answer.
I can't hear you. One more time.
Okay. You understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause that you had something to do with committing that crime. Do you understand that?
Yes.
A little louder, please. You gotta give your answer a little louder.
Yes.
Okay, thank you. All right, anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
One more time.
You're waiving your right for exam only freely and voluntarily after having opportunity to talk to your attorney about it?
Correct.
Couldn't hear you.
Okay.
Okay.
Okay, that's yes?
Yes.
All right, thank you.
The microphone.
All right, do you have any objection to the court signing your name to the waiver form and initialing off?
No.
Mr. Schuman, do you have any objection to the court signing your name to the waiver form and initialing off?
I do not.
All right, court will find that you freely and voluntarily waive your right to preliminary exam as bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be June 7th, 2023 at 9:00 a.m.
Thank you.
Okay, all right, thank you.
Thanks, Judge. Please continue.
Mr. Turner, you can tell them we're done now. You can tell the deputies that we're done now, we're finished.
Okay, thank you.
Thank you, take care.
So Judge, we only have one more PCC. Yeah, and you see she has a 9:30, so I'm wondering if she did that. I was like.
She's gonna start making them. I don't know what else I can do. Besides hold her. No. Oh, she don't want to show up?
Over on the other.
We ready on our 9?
The way, well, everyone's here. The young man who's in a wheelchair is trying to get out. That was, I don't know how long ago, that was about 5 minutes ago, so he might be on his way out.
Mr. Thompson, we're just waiting on your attorney, okay? We gotta get you another. Good morning, sir. Zero 9 3 6 0 1. That's correct. That's correct. Thank you. All right.
Judge, I'll bring Mr. Konecki in, and I would just ask you to approach with Mr. Konecki when I bring him in.
Oh, for witness.
He's supposed to be on his way. Mr. Konecki's class.
Is this regarding your witness not being here?
It is,
Do
Your
this
Honor.
on the record. I'm not doing a sidebar.
Okay.
Do it on the record.
Understood.
What do you call it, Judge?
Yes, please.
You ready, Kim?
Yes.
Calling case number 2356530, the people of the state of Michigan versus Keith Williams. Defendant is charged with count 1, assault with intent to murder, count 2, home invasion first degree, count 3, stalking aggravated. This matter is scheduled for exam.
Good morning, Your Honor. Crystal Murphy, P83362 for the people.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800 on behalf of Mr. Williams. So please state your name for the record.
Good morning, Your Honor. My name is Keith Williams.
Morning.
Your Honor, as the court can see, the witnesses, I have two witnesses for today. They're not here. However, the situation with the one witness, he's in a wheelchair. He's severely disabled. He had transportation this morning that my office called for to go and get him. I have my OIC here to kind of help facilitate on what's going on. I personally just went downstairs to lay eyes on the situation to see who I could see what was going on, because there's been a lot of back and forth between everybody.
My officer, my court officer was told he was downstairs and they were working on getting him up here. And now I'm told that he's not even here.
That was my understanding, Your Honor, so I apologize if there was a misunderstanding with multiple people talking back and forth. That's why I went downstairs just to lay eyes on what was going on, to see for myself. I saw my OIC waiting, and then I realized, okay, he's not down here, my OIC is waiting. My OIC spoke with the female witness for today, who indicated that she was dropping the kids off, and the male witness was on his way in a van. I had no, and I would tell the court, I had no communication issues whatsoever with these two witnesses. They've been very involved, they've been very communicative with me. Given the gentleman's disabled state right now, I would just ask for if we could have 12 minutes to see him, to see if he gets here on time. It's currently 9:18, if we could wait till 9:30. I would greatly appreciate it, just given the situation with him being in a wheelchair, having to have transportation issues, and then also the female witness apparently having to drop her kids off this morning. And if they're not here in 12 minutes, then I understand the court has to do what it has to do. Thank you.
Obviously, Your Honor, we're prepared to go and we would move to dismiss.
I'm gonna give him time.
Thank you, Judge.
Thank you, Your Honor, I appreciate it. Appointment with the heart doctor, cardiologist. Did you usually? Because you said next to it. Oh. Right. Excuse me. Yeah. That's good. Which one? Oh, where it fills up? Oh. Did it drop? I hate that. It's not her mom. So they say, Judge, so they said my dad has a clogged artery in his like neck. I
I don't know, he's going to see the cardiologist today. He's already out of there.
Yes, negative for the brain,
They said it's in
which
his
could
head.
cause a stroke.
Yeah.
Right.
Yeah, I know. They found out when he had chest pains, a couple weeks ago, so he drove himself. He would get up and go, hey, he drove himself, I mean, I'm thankful, but sometimes he just won't call, he'll just go do it. So he, went to Henry Ford, and they did an observation, that's what they found. And they found his, they said his kidney is bad too. It's like hanging on the edge. Huh? No, it's funny. I told you the experience with him, Henry Ford. About him. That's his favorite hospital, Henry Ford. So, a couple weeks ago when he went, he did not have a good experience. He called me, I think it was 4:30 in the morning, saying it's a conspiracy. They're doing illegal activity. Yeah, you know. Because they took a picture of his driver's license. Sorry. And they put it in the system. I'm on the side. He said it's conspiracy. They're doing some illegal activity.
See what it is, things are changing, you just don't.
Yeah, yeah, he don't.
You shall see.
Should have told him to bring lunch.
Yeah, but he can't do nothing, as far as I know. He can't handle surgery.
About
90. My dad is like, so we're talking yesterday, he said, well, can these pills cure me? Are they gonna cure me?
So, yeah, I guess I already paid money for you.
Oh, sorry, I'm gonna cure you, buddy.
Gotta take him to the motherland. You guys. Because they're gonna try to kill you. Gotta keep you on that, those drugs.
That's right. Yeah.
You know, what's so cool, he's still out. He's serious.
I'm saying, he's serious, he ain't trying to be funny, he's serious.
Yeah, but it's really like.
Funny to us. He's serious.
Is that serious?
Pretty much.
There's my witness, the male witness is here, so we're gonna be ready, the OIC is just gonna come upstairs.
Yeah, that's that PCC. They're nice if we could have did this before this exam started. I take it this was very good.
Yes.
Why you put it way
Because I know how you can be. What you did. Right. Good morning.
was not paying attention. So, sure.
Says.
No, that should be fine. Just, I'm assuming it's probably gonna be right here, right?
Yes.
That can be the easiest with the wheelchair?
Yeah.
Right, okay. Then yeah, that volume should be good.
Okay.
Guys, whenever the court's ready, the witness is out in the hallway.
All right. All right, this is recalling 2356530. That's people of the state of Michigan versus Keith Roy Williams.
Good morning again, Your Honor. Crystal Murphy on behalf of the people.
Jeffrey Konecki of NDS on behalf of Mr. Moore. Thank you.
Preliminary issue.
Just a few, Your Honor. One, I wanted to make everyone aware far in advance of one of my witnesses' speech difficulties. He had a severe stroke and his speech is very limited. Because of that, I was able to get my hands on a device, essentially a text-talk device. I informed the court as well as Mr. Konecki of my plan to do this. At that point, the plan had yet to materialize. However, I have that device now. It's in court. I looked at it with Mr. Konecki. I know that we have to provide reasonable accommodations to disabled witnesses. However, for what it's worth, I don't think Mr. Konecki has an objection.
No, Your Honor, Madam Prosecutor did discuss the use that device. We did look at it. It appears to be just that. It's as the words are put in and you hit the button and it does state them. It states them at quite a decent volume. The court should be able to hear it. I have no objection to the use of the device. It's going to facilitate gathering the information in this case much easier.
Okay, so he has to type in his answer.
Essentially, Your Honor, and if the court would allow for some leading to help facilitate his responses, I don't think that his testimony will be terribly long substantively, but it might take a little while for him to type in his answers.
Your Honor, I don't necessarily have an objection to the prosecutor using yes or no questions, but the leading I would still have an issue with. But if she wants to ask yes or no questions, which don't suggest the answer, I have no problem with that.
Right now, You can ask leading questions in a variety of different ways. For example, you can ask a question that suggests the answer, or you could ask a question that suggests the answer by providing evidence that has not been put on the record yet. You know, I don't have an issue with you asking yes and no questions based on the evidence that's already been.
Understood, Your Honor, thank you.
Okay.
And then, I'll move on to the second, preliminary matter. As the court saw, there's an aggravated, stalking count, and the basis for that was a certain, PPO. And I have the certified, I have the whole thing, I have the certified, order, petition, as well as proof of service. I showed Mr. Kanaki all of this ahead of time. They went a little bit crazy with the stapling. They stapled all sorts of stuff on these items. I didn't want to disturb the staples ahead of court, so I showed that to Mr. Kanaki today. There are 3 stapled pages. I marked them as proposed exhibits 1A, B, and C. I would just need to admit those under 76611B.
No objection for exam purposes.
All right, there'll be a minute.
Thank you, Your Honor. May I approach with the exhibits? And then, Your Honor, just 2 more brief things. I'll wait until the end to see what the proofs are, but I imagine I'll be moving to bind over on an attempt home invasion first degree as opposed to just a regular home invasion first, but I'll wait until the end. And then lastly, I let Mr. Kaneki know my intention to add a additional count 4, a computers count. It's the PAT code 750.1227B based on the proofs, but again, I'll wait until the end to officially ask the court to add that. Last but not least, I
didn't hear that last part. You said you're moving to add a count of what?
I'll wait until the end, but
but I need to know, as Nicky needs to know, so that he has advance notice, otherwise, no notice, I don't allow it.
Absolutely, Your Honor. I actually emailed Mr. Kaneki yesterday with my intention of adding this particular count if the proofs show. It's the full.
I just need to know what it is.
Absolutely, Your Honor. It's count computers used to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. And then the underlying basis for that would be the aggravated stalking.
Okay.
Yeah, it's the.
All right, Mr. Kaneki, you're on notice?
Yes, Your Honor. I just.
All right, and that's the exhibit 1. I don't know if I said it, but it is admitted.
Thank you, Your Honor.
A, B, and C or 1?
It's exhibit 1
1, A, B, and
of
C.
the 3 parts, A, B, and C, 1, A, B, and C.
Thank you, Your Honor. And then just last but not least, I would just move for a mutual order of sequestration, with the exception of my officer in charge who's out in the hall.
The officer in charge testifying,
Not today, no.
the objection?
No, Your Honor.
All right, any of our witnesses testifying today at trial or any time in the future must leave the courtroom or be denied their future testimony. That includes Zoom and on YouTube, with exception to the officer in charge.
Thank you, Your Honor. The people call James Crawford, and I will go get him.
Come in around that way. Mr. Williams, scoot back 1 row just so that he can get through, please.
This is the net.
We'll go through, okay, never mind, we'll go through this.
He said never mind, he can move back.
Correct.
Right here, good.
Where's the machine he has to use?
He has it down.
It's right here, sir.
Okay.
Just
Good.
Okay.
All right, Mr. Crawford, I need you to raise your right hand, can you? No, okay, don't worry about that. All right, Mr. Crawford, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you. All right.
Thank you, Your Honor. Good morning, Mr. Crawford. I'm going to take your attention back to January 30th of this year, of 2023. Were you in the area of 2258 West Grand Boulevard, City of Detroit, Wayne County?
Yes.
Okay. And was that particular location residence, business?
Apartment.
Apartment. Okay. Were you there alone or with other people?
With others.
Who was there?
My children. Mother. And my kids.
What is the name of your children's mother?
Destiny.
Okay. Did an incident happen at that location that morning?
Yes.
And do you recognize anyone in the courtroom who was involved in that incident?
Yes.
Can you please indicate where in the courtroom that person is? And also identify an article of clothing that that person wearing?
Right, sure.
I didn't catch that.
Can you type that?
It's a black shirt. Very good.
Okay, and can you just indicate where
You
at?
already pointed to them, got it.
Okay, thank you, Your Honor. Your Honor, in the record reflect the witnesses identify the defendant.
Right, that's all reflect.
Thank you, Your Honor. Okay, regarding the incident, what happened?
Well, proceed by, yes, and, you're asking for a narrative, and I think that's gonna take too long and be too difficult on this with us. Proceed by questioning.
Fair, Your Honor, I will absolutely. Okay,
The court again will allow some leave.
thank you. Mr. Carver, I'm not at the I think he's trying to communicate with me. I can't, so if you could.
Just wait for the next question, Mr. Crawford.
Yeah, okay. So I just asked you about the incident, so we're gonna kind of take it piece by piece. So did the incident happen in the morning?
Yes.
Okay. And what was the first thing that happened?
I answered the door.
Okay, you answered the door, so does that mean that you heard a knock on the door?
Yes.
Okay, and when you heard the knock on the door and answered the door, what happened next?
The defendant was standing there and no words were exchanged and I closed the defendant was standing there and no words were exchanged and I closed the door.
Okay, so after you closed the door, what happened?
He proceeded the he process proceeded to kick the door and yell obscenity.
Okay, so you indicated that you closed the door, defendant then kicked the door down?
No, it just said he kicked the door.
I'm sorry, he kicked the door. After he kicked the door opened.
No.
He kept kicking till the door came. Look. Door. Lock. He kept kicking till the door lock broke.
Okay. When the door lock broke, what happened next?
I went to confront. I went to confront him.
Okay, so you indicated defendant was kicking the door, the lock broke, and then you went to confront him. So yes or no, were you at the door at this point, standing right by it?
No. No.
You said no, okay. Where were you in that? Where were you at?
Living room.
Living room, okay. What happened next?
When we went out to confront him, I swung two, punches, and then he stubbed stabbed me in the neck.
Okay, the defendant stabbed you in the neck? All right, and before, I'm gonna have a couple more questions, I'm almost done. I don't want you to feel pressured to type fast. I understand you're typing with one hand, so it's okay to go slow. Just a couple more questions. When the defendant stabbed you in the neck, were you inside the apartment?
No.
No? Okay. Where were you at when the defendant stabbed you in the neck?
In the hallway.
You were in the hallway?
Yes.
Okay. All right, a couple more questions and I'm almost done. Regarding the door lock being broken, did you see what happened to the door after the door lock was broken?
What do you mean?
What do I mean? I'm gonna rephrase, that was a bad question. So when the door lock to the door broke, did you see that happen?
Yes.
You saw it happen, okay. Now, when you saw it happen, the door lock breaking, how did you know the door lock broke?
It came.
It came. It came open.
The door came open?
Yes.
Yes? Okay. Did the defendant ever come inside, yes or no?
No.
No? Okay. Okay, you indicated that you were stabbed out in the hallway?
Yes.
Okay. What, if you remember, what happened after you were stabbed in the hallway?
I ran down the hallway to keep him away from the apartment. He then proceeded to chase behind me. I ran down the hallway to keep him away from the apartment. He then proceeded to chase behind me.
What were you thinking at that time?
My family safety. My family safety.
Okay. And did you go to the hospital after this incident?
Yes.
Yes, okay. And if you know, if not, that's okay. Did you spend, how long did you spend in the hospital?
3 months.
You spent 3 months in the hospital? Okay.
In rehab.
In rehab, you said? Okay. Your Honor, I have no further questions for this witness at this time.
Thank you.
Mr. Crawford, again, I'm gonna ask you some questions. If you don't understand it, let me know, and by all means, just take your time, type your responses. I'm gonna try to do as many yes and no as possible, but Mr. Crawford, have you been convicted of a crime involving theft or dishonesty in the last 10 years?
Objection, Your Honor, that's not the question. It would be a felony. That's for impeachment purposes, not a misdemeanor.
Mr. Crawford, have you been convicted of a felony involving theft or dishonesty in the last 10 years?
No.
On this date, on January 30th, were you using any drugs, alcohol, or prescription medication that would affect your memory?
No.
Were you, and on January 30th of 23, living with Mr. Williams' daughter?
No.
No, she was not living with you and Destiny?
No.
Was she there that day?
Yeah.
Okay. So she was with you that day?
Your Honor, I'm gonna have to object as to relevance.
Relevant.
Just trying to establish who's there. In addition to, he indicated there were a number of his children, but I'm just trying to see who else is there that are potential witnesses.
The first question was she living there? How is that relevant?
Well, I'll withdraw that one and simply was Mr. Williams' daughter present that day? And you indicated yes, is that fair?
Yeah.
Okay. And you said Destiny was there, correct?
Yeah.
Okay. And then your children, correct?
My son.
Son, okay. How old is your son?
He was 2 months at the time. He was 2 months at the time.
Thank you. Was there anyone else in the apartment besides yourself, Destiny, your son, and Mr. Williams' daughter?
No.
Thank you. Now, you indicated that you answered the door and Mr. Williams was there, correct? Is that?
Yeah.
Thank you. I was a little confused when you first answered the door and he was there. I heard words were exchanged and possibly no words were exchanged. I just want to clarify.
No. No words.
Thank you. So that's when you closed the door and went back into the apartment, correct?
Yeah.
Okay. And then after that is when you hear banging on the door.
Yeah.
And you indicated you also heard him yelling?
Yeah.
Okay. And when the door lock broke, when you heard them, back up. When you were in the living room and you heard the banging on the door, how many bangs was it before the door lock broke?
Not sure.
Fair enough. After a series of bangs, you indicate the door lock broke, yes?
Yeah.
Okay. And when the door lock broke, you went out into the hallway to confront Mr. Williams, correct?
Yeah.
Okay. You indicated he never came into the apartment?
No.
Okay. When you went out in the hallway, you indicated you threw punches, correct?
2.
You threw 2 punches?
Yeah.
Okay. Where were you when you threw the 2 punches?
In the hallway.
Okay. Were you in the hallway just outside your door or were you further down in the hall?
Right. Outside the door. Right outside the door.
When you went out in the hallway, did you close the door behind you?
No.
So as far as you know, the door to the apartment was open when you went out into the hallway and were fighting with Mr. Williams. Is that correct?
No.
So the door was closed when you went out in the hallway.
When destiny. Immediately closed the door. Be used behind me.
And when you went out into the hallway, did you say anything to Mr. Williams or did you attack him immediately? And you indicated you threw 2 punches, correct?
Yeah.
Okay. And when you threw those punches, did you hit Mr. Williams?
No.
No? And after he threw the 2 punches, after you threw the 2 punches, did you guys drift further from the door to your apartment?
No.
Okay. And so it was there when there was more of a struggle, correct?
No. Struggle. No struggle.
So there wasn't a struggle. You threw the punches and Mr. Williams then defended himself from your attack, correct?
That's not the testimony.
No. He stabbed. No, he stabbed.
So.
No, he stabbed me.
Mr. Williams stabbed you after you tried to punch him, correct?
Yeah.
Okay. So you attempted to attack and make physical contact with Mr. Williams in the hall.
I'm gonna have to object. There's been a lot of mischaracterizing the testimony.
You don't have to leave that up to the jury. That is not what I'm hearing.
He indicated
he
went out.
got his door kicked in. He went outside. He swung a couple times at the guy, your defendant, or the defendant, and the defendant then produced the knife and stabbed him in the neck.
Well, I actually, Your Honor, I don't believe that the defendant producing a knife is during the testimony of that. All I heard was fight and a stab. And I'm still a question trying to get into that issue. But
You're right. Maybe I'll strike the part about the knife. He got stabbed in the neck.
Yes, Your Honor, that is the testimony, but I don't believe it's a mischaracterization.
If you're saying he tried to defend himself, then this exam is over because that is an issue of fact for the trier of fact. If you're saying, if your defense is self-defense, we're finished. It's over because it's a question of fact already. You're admitting that it's a question of fact.
Even if that is the case, I still can explore and ask more questions to gather more information about what happened out there. This is my first opportunity to ask questions of this witness. We did have
No. I understand that. It technically is your first opportunity to ask questions, but I only have to get probable cause. Once probable cause is there, we're through. And if you're saying your defense is self-defense, then we're through. It's over. There's nothing else to go through.
I'm not saying anything.
You are saying it in forms of your question.
But I'm just trying to gather the information, Judge, so that I know. And even if the court believes that probable cause has been reached, at this point, I believe I'm still entitled to ask him questions about other aspects of it, other things that may affect the trial down the road or a potential motion hearing or things. And that's what I'm trying to get at the bottom of his version of the testimony, because I anticipate the other witness having already testified once and is here today with the intent of testifying. I need to know what details he is saying so that they can be compared to what details she says. That may be information where they tell 2 completely different stories, and that's important to the jury.
I'm gonna give you some leeway.
Thank you, Judge. I don't have much more. So, Mr. Crawford, you were right in front of the door when you were stabbed, correct?
Yeah.
Okay, about how far away from the door, if you know, was it less than 5 feet?
Yeah.
Okay, and then you did tell us though, after you were stabbed, you got up and you ran back to the apartment, correct?
No.
You didn't testify to that?
No.
Okay, that never, no. You've answered that. You went into the apartment and you indicated Mr. Williams never went into your apartment, correct?
No.
Okay. When you went out to confront Mr. Williams, did you bring any object or weapon with you?
No.
Did you see what object you were stabbed?
A knife.
Did you see what color the knife was?
No.
Did you see about how long the blade was?
About 4. Inches.
Could you see a handle?
No.
Did you know if it was, what was it, more of a hunting knife or a kitchen knife, if you know?
I don't know the specific kind. I don't know the specific kind.
Did you see the knife before or after you were stabbed? After. And you went back into your apartment, correct?
No.
2.
No.
I ran down the hallway.
You ran down the hallway to your apartment?
No.
Okay. Did you run towards a stairwell?
Yeah.
Okay. Where did you go when you ran to the stairwell?
No.
I didn't hear it. I'm sorry.
Nowhere. He proceeded to attack me again.
Where did he attack you again? In the stairwell?
By the elevator and stairwell. By the elevator and stairwell.
Do you know how many apartments are on this floor of your apartment building?
Oh.
Is there more than just your apartment?
Your Honor, I'm gonna have to object to relevance.
I'm just trying to see who else this is exploring to see who else may have heard or saw the commotion in the hallway.
Well, you can do that to an investigator. I mean, come on.
I'm just trying to figure out if there's more than one apartment. If this is the only one on the floor, obviously there's no reason to explore that. Are there other apartments on your floor besides yours?
Not 100.
Just your apartment?
Not my apartment. Not my apartment.
Is it Destiny's apartment?
Yeah,
Are there more apartments on the floor than just Destiny's apartment?
yeah.
Okay, thank you. One second. Nothing further.
One question, Your Honor, really briefly. Mr. Crawford, do you have any type of scarring on your neck from the stabbing?
Objection.
I think it goes to the injury, it goes to what the defendant intended in terms of how long the stab was, what's, no, understood, I'll move on. With that, Your Honor, I have no further questions.
Thank you. Thank you, Mr. Crawford.
And then, Your Honor, I'm just gonna grab the device really quick to give to the device. Your Honor, just one more witness, for the people called, Destiny Connell.
Destiny, Destiny, Connell, Connell.
Ma'am. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Close the door, please.
I didn't hear you, ma'am.
Yes, sir.
All right. Connell, you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will probably ask you some questions. And I may or may not ask you questions, right? So you have to answer all your questions out loud verbally using words. You just can't shake your head or say, you have to say yes, no, or whatever the answer is, okay?
Yes, sir.
Also, when you ask a question, I need you to, listen to the question, just answer that question, and then stop. If it's a yes or no type question, just say yes or no. If they need additional information from you, they'll just ask you another question, all right?
Yes, sir.
We all have a tendency when something traumatic has happened, we tend to ramble because we want to get the whole story out, all right? We want to say this happened, and this happened, and this happened, and this happened. If you do that, I'm going to miss something. If I miss something, I might not make the right decision, all right?
Yes,
I
sir.
get all my information from what happened in court. That's why we take it one question, one answer at a time, okay?
Yes, sir.
All right, thank you. Proceed.
Thank you, Your Honor.
Bless you.
Good morning, Ms. Connell. I'm going to take your attention back to January 30th of this year, 2023. Were you at home that morning?
Yes, ma'am.
And at that time was home 2258 West Grand Boulevard?
Yes, ma'am.
And is that address in the city of Detroit, Wayne County?
Yes, ma'am.
Okay. And on that day, that morning, were you home alone or with other people?
Someone else was there.
Okay, who all was there?
My two children and my son's father, James Crawford.
Your son's father, James Crawford. Okay. And your two children who were home at the time, how old are they?
At the time, they were 2 months and 1 year old.
Okay. No, sons, daughters,
Yes.
I'll get there, Your Honor. It is relevant, but I'll get there. It's just a little bit of leeway.
2-month-old and a 1-year-old.
Okay, the 2-month-old, is the 2-month-old a son or a daughter?
My son, and that's with Crawford. My 1-year-old is with Williams.
Understood. Okay, you're 1-year-old. Okay, all right. So, did an incident happen that day, that morning at that location?
Yes.
Okay, and do you recognize anyone in the courtroom who was involved in that incident?
Yes, ma'am.
Can you please indicate where that person is at and also identify an article of clothing that they're wearing?
Sitting right there, a dusty black vest on.
Your Honor, may the record reflect the witness has identified the defendant. She did point.
Record so reflect.
Thank you, Your Honor. The person that you just identified in court, do you know his full name?
Yes.
What is his full name?
Keith Leroy Williams, the second, third, or something like that.
Okay, but Keith Leroy Williams?
Yeah.
All right. And how do you know this person?
That's my daughter's father, unfortunately.
And how long have you, approximately, how long have you known this person for?
My daughter's now, what, 2? So some years now, maybe.
One of the next questions.
Understood, Your Honor. Thank you. Do you have a daughter with anyone else?
No.
Okay. So we'll take it in chunks. I'll start at the beginning and we'll go from there. Before we get to the incident, and I ask you questions about that, was there anything that happened leading up to the incident right before?
Yes.
What happened?
I received a stream of threatening messages from Williams, like maybe 2-3 days prior to January 30th, of him threatening me, saying he would slaw me and dump my body in an alley and all types of other stuff, threatening my whereabouts because I do rely on public transportation. And because he knows that and has gone with me to, routes that I take on the bus.
Hold on 1 second. It means you receive my question and answer. Mr. Williams.
Yes, sir.
You get to sit here and watch. You have the right to confront through your attorney. You don't have the right to respond or react. Do you understand that?
Yes, sir.
So you start huffing and puffing and shaking your head, you won't be sitting in here. You'll be sitting back there. You understand?
Yes, sir.
Okay.
Thank you, Your Honor. All right, so you indicated some threatening messages. I think I know, but I don't want to assume. How did those messages come to you?
Through text.
Through text messages?
Yes.
Okay. And did you have the defendant's phone number saved in your phone?
At the time, yes.
And did you have the name, or excuse me, I'll back off. Did you have that number saved under a name?
Yeah.
What was the name you had it saved under?
Dummy.
Okay.
I couldn't hear you, I'm sorry.
Dummy.
Okay, like DUMMY?
Yeah.
Okay. Regarding the messages or the exchanges leading up to the incident that I got to ask questions about, would you recognize the conversation or part of that conversation?
Yes.
Okay. Your Honor, may I approach the witness? I previously shown Mr. Konecki's Sorry, Judge, I was just making sure Mr. Konecki was following along with the ones that I'm going to report with. It's 5 sheets of paper. It's been marked as equal proposed exhibits 2 through 6. Approach.
Yes.
Thank you. And then Ms. Connell, I'm gonna ask you some questions about that stack of paper I just handed to you, and I'm gonna start just one by one. So the first page up on the very top, that's the marked as equal proposed exhibit number 2. What did I just hand you? On the top page?
A text message from, Dummy.
Okay, and do you recognize that text message exchange?
I do.
With that text message exchange that you recognize, was that between yourself and the defendant?
Yes.
And has that exchange been changed in any way? Is that an accurate depiction of the portion of that conversation that you had with him?
No, this is pretty accurate.
It's accurate?
Yes.
Okay. Your Honor, the people would move to admit people's proposed exhibits to into evidence.
No objection for example.
And then, I'll ask if it's not okay, Mr. Kennedy, I understand, but would you stipulate to admitting the rest? Because I'm just gonna go through the same process.
Yeah, the 5 pages that are marked, I have no problem with those being admitted for exam purposes. I don't believe the witness should just be reading them. She can be asked questions about them.
She can be asked, once they're admitted, the court can read them. I don't need her to read them for me.
And Judge, I'm just gonna ask a couple questions based off of the admitted exhibits, and then I'll make certain arguments and guide over, so I won't have. Regarding those admitted exhibits, so that would be people's admitted 2 through 6, are there colors of the text message exchange? So basically what I'm asking is, which one's you and which one's him?
I am in the lighter orange and he is in the darker.
Okay, understood. Now, a couple more questions based off of those messages on the first page, so people's exhibit to the very top page. When did that start? Is there a date on there?
Can you repeat that question, please?
Absolutely. So is there a date and time on page number 1, people's exhibit?
I'm gonna object to, again, to having her read the question. You can ask her what date and time these things happened, if she needs to refresh her recollection, but again, we're going right to just reading what's on the paper.
Yeah. If I may briefly, Your Honor, since it admitted exhibit, I'm not asking to read verbatim all of the text messages, simply about what date.
You're asking her about the date. She already said, she said it was a couple of days before this incident. That's what she testified to so far. If you want an exact date, you can ask if she knows. If she doesn't know, she can refresh her memory, but the way you're doing it is just not proper.
Fair, understood, Judge. Regarding those text messages, what you have in your hand right now, those sheets of paper,
Yes.
do you know the date and time that those happened at?
Yes.
Okay, what was the date and time that those happened at?
These happened, it says here, January 30th.
Okay, you can't read off of that. You have to ask the right question.
Your Honor, thank you. So in terms of, do you recall that exchange, that text message exchange?
Yes.
Okay, and that text message exchange, do you recall when it happened?
Yes.
Okay.
He started messaging me 2 days prior to January 30th. So these started like January 27th, 28th, where he wanted to asked me a question and he was not okay with my response. So he began to press me and threatening messages because he was uncomfortable and didn't like the way I answered a question.
Okay, so you indicated that the threat started a couple days ahead of January 30th. Did they continue on to other days?
Yes.
Okay, when did they continue on to what days?
Well, whenever he would feel like it, honestly. Because literally the last message I received from him was like May 2nd.
Okay, so let's go before the incident, before we talked about the incident. The messages that you have in your hand right now, do you recall when those took place?
Yes.
When? The ones you have in your hand.
January 27th through the 30th.
Okay, so the threats occurred up until the 30th?
Yes.
Understood, okay. Now, regarding the incident, so let's go to the morning of the incident. how did that particular day start off, the morning, when you woke up?
Well, I woke up that morning, got my kids dressed to take them to school. I noticed my daughter had a cough, so I left her home. I left her out. I was uncomfortable with her going to school, snotty and things like that. So we took my oldest son to school, Crawford and I. We get home, and it's like 8:52. Like, it's early still, because my youngest son, my 2-month-old, was still in the car seat at the time. And my daughter went to sleep on the route back, laid her down. I'm in the bathroom, Crawford is in my room. I get a knock at the door. But while I'm getting this knock at the door, I'm still getting texts from him, like, yo, I'm on my way, I'll be by the.
See my question and answer, not narrative,
And
please.
Your Honor, if I may briefly, can I approach the witness and retrieve the text messages and publish to the court?
Yes.
Thank you. Okay, Ms. Connell, you indicated that you were at home, getting your kids taken care of, and then you were receiving messages from.
I'm still receiving messages from him while I'm in the bathroom.
You gotta wait for the question, please.
I'm sorry.
Okay. So you received the messages while you're in the bathroom. What happened next after you were receiving the messages in the bathroom?
I began to hear a knock at the door. So I'm actually lying to Williams, like, I'm not home, so that he can like kind of go away, you know, like maybe if I'm still enough, quiet enough, he'd just go away, because he's done that, and I've acted like I was at home on several occasions before. So I'm like, if I just don't say anything, he'll go away.
And you didn't want him there, is that fair?
No, I didn't want him there.
Okay, all right. So, after you heard the knock at the door, where were you at?
I was in the bathroom at the time.
Okay, and then was there a point in time where you left the bathroom?
Yes,
And when you left the bathroom, where did you go?
to my living room.
All right, and when you were in your living room, was anyone else nearby you in the living room?
Yes, Crawford.
Crawford was by you?
Yes,
And is Crawford's first name James?
yes.
Okay, and then, what happened next when you were in the living room?
Well, actually, while I was still in the bathroom, I hear the knock at the door. James comes out of the room. I'm like, yo, James, that's key, you know, because that's key, you know. So he like, oh, well, you know, like, what is it? It's 8:00 in the morning, he's knocking me at the door, you know, he answers, hey, you know, what's going on?
And I think I know what you're saying, but again, I just want to make sure we're clear for the record. When you say that he answered the door, was it James?
Yes,
Okay.
James answered the door.
And were you still in the living room at this
I'm
point?
in the bathroom still.
Okay,
I'm still in the bathroom.
could you see them?
Yes, because from where my bathroom is, you look to the left, my door is literally in that hallway of the restroom.
Okay, and when you were, at that point in time, when you saw them, what if anything did you see take place?
Just a conversation. When James opened the door, he began to say like, really, Destiny? Really, you in there with this? And he began to shout all kinds of obscenities in the hallway. So James then closes the door, like, oh, well, you don't want me. So he closes the door and he, you know, walks off and goes about the house. Actually, I think he goes back in a room or something to lay down because it was still early in the morning and he had to be to work actually, so.
Okay, and then, so James closes the door, walks away.
Mhm.
Where were you in the living room at this point, or where were you at?
At this point, I grabbed my phone, I called the police because we do have a protective order. I do have a protective order against him. So at this point, I get my phone, I come out of the bathroom, go to the living room, I call the police. From there, Williams is steady kicking and banging at the door, of course, more aggressively at this point, because now he knows I'm there and he also knows that James is there with me, okay? So he's beating and banging all at the door, let me in. At this point, James goes to try to put his shoes on because he had on like, you know, regular clothes. You know, he had on flip-flops. So he like, you know, let me put my shoes on.
And
know.
and I'm so sorry, I'm not trying to be rude, with, when James was gonna go put his shoes on, was he, in the living room by the door, where was he?
He was in
at?
the living room.
Okay,
We were still in the living room.
and you said you called the police, are you kind of?
I'm on the phone with the police. James is trying to put on his shoes. Keith is still kicking and banging and screaming at the door. While I'm on the phone with the police, the door pops open. From there, James is like, he was like right there, like almost like the door, like kind of hit him, being popped and kicked open like that, you know? So it's like them two almost, from where I sat, it's almost like they, not really a hugging match, but it was more like a collide almost, you know what I'm saying?
Okay.
And after that, I honestly went into a full panic, pushed myself up against the door as best I could, because the way my hallway is set up from my door is really not that much distance, because my bedroom is behind it. So I'm on the floor and I'm pressing out with my feet, trying to hold the door, because it's completely popped. Like it's almost swinging at this point.
Okay. And okay, so I just want to understand kind of where you were at. So you said that you're sitting on the ground at this point and you have your back up against the door?
Yes,
And when you
scared that somebody's gonna try to come back in.
Okay, and you indicated that you were scared.
Yeah.
Where were your kids at that point?
My son was actually in the living room, still in the car seat, and my daughter was in her room, in her bed.
Okay. And while you were sitting on the ground with your back against the door, what was going through your mind?
Like, oh snap, like, oh my goodness, like, what is happening? Like, it really felt like a movie. It felt like one big dream. I was terrified, you know. I'm not gonna say I'm afraid of Williams. I'm just always unsure of him. You know what I'm saying? I'm always unsure of him because I never know if he's gonna snap, flip out. I don't do a certain thing he wants.
Okay, you need to proceed by question answer, please.
Yes, Your Honor. No, it's okay, it's okay. So, when you were sitting on the ground, what, if anything, did you hear?
I heard running. And in the midst of that, I hear like this loud groan almost. I hear a door close. And more running.
Okay, was there a point in time where you stood up from having your back against the door?
After Crawford basically came in, like holding his neck, like he, you know, pushed his way in, you know, because I'm still up against the door. I didn't know who was coming in the house, honestly, but I was seeing him spewing blood everywhere.
Okay, so you're trying to keep the door shut, you know, you're trying to, again, I don't want to assume you're trying to keep your
I'm
kids
trying
safe.
to keep the door shut and trying to keep my kids safe in there because I was unsure at this point what he was gonna do. Like,
And then Crawford,
pushed past where I was trying to push my weight. At the time, he still had his strength, you know, and
you talked about blood. Can you
Yes.
help me understand more what you saw in regards to blood?
it was blood everywhere. And because he was, I guess, panicking or excited, adrenaline at the time, it was just spewing everywhere, like all over my white walls, all on the floor, all on our child, you know, because at this point, he really thought he was gonna die. So he's like,
Okay, you can proceed by question and answer.
Yes, Your
counsel,
Honor.
Please.
Almost done, just a couple more questions. Okay, so, in regard to, you indicated that you had a personal protection order against, defendant. Do
Yes.
you recall what year?
I don't need that. I have.
Understood, Your Honor. After Crawford came back in the house, and you indicated that blood was spewing everywhere.
Yes.
Correct me if I'm wrong, I believe you indicated he was holding his neck.
He was holding his neck on the left side, and he's like, oh, I'm hurt, I'm hit. Like,
Can't testify what he says.
I'm
That's
sorry.
why proceed by question and answer.
Your Honor, I would submit to the board that that's excited utterance. So with that, he indicated that he was hit?
Yes.
Okay.
Like, that nigga, he got
I
it.
was gonna object that there's still no foundation for an excited utterance.
Your Honor,
Just because she says there's one doesn't mean.
I think that there's been sufficient testimony to indicate that would be an excited utterance. If the court wants, I'm happy to ask another couple questions, but I think there's been sufficient testimony.
Yeah, I think based on Alice's testimony, it is more than enough sufficient for the allowance.
Thank you, Your
I
Honor.
got it.
Okay, understood. So at that point in time, what, if anything, did you do?
I just tried to be there for him, tried to put pressure on the wound, try to like keep an eye and ear out for my other children that were there. I'm still on the phone with the police. I'm begging her to just please send somebody.
All right, and did the police show up?
Yeah, they showed up.
Okay.
Police showed up first in the EMS, and then they got him on in a truck.
Your Honor, I have no further questions for this witness at this time. Thank you.
Just give me a second, Mr. Cocker, sorry. Go ahead.
Ms. Connell, you indicated that, did you call 911 after James first opened the door and then closed?
Called him before.
Okay, so you called 911 when there was the initial knock on the door?
Immediately.
Okay, thank you. Now, in the text messages, you have a contact that's named Dummy, correct?
Yes.
What phone number is associated with the contact Dummy?
I'm honestly not sure, because he goes through so many to contact me. So that was just the one that I had on hand at the time.
Okay, so and how long had the contact Dummy been in your phone with this number?
I'm honestly not sure, because again, he changes them so much to contact me.
How many phone numbers has he had in the time you've known him?
At least 50 to 75.
And how long have you known him?
For, give or take, maybe 5 years.
So in that time, he's had 50 to 75 different phone numbers?
Yes.
Okay.
And social media accounts as well.
You indicated you took somebody to school that morning?
Yes, my son.
Okay. How old is your son that you took to school?
5.
And then your that son is not with either Mr. Williams or Mr. Crawford, is that
No,
fair?
that son is with Crawford.
Okay, the 5-year-old?
Yes.
Okay, and then there's also a 2-month-old?
Yes.
That's also with Mr. Crawford?
Yes.
Okay.
No, Your Honor, nothing further.
Thank you, ma'am. Waiting for the witnesses? Yes.
No, Your Honor.
Guys, any witnesses?
No, Your Honor.
All right, for you, I need to read the exhibit 236.
Okay, thank you, Your Honor.
All right.
Thank you, Your Honor. The people who provide over, as to count number one, the people who provide over as charged with assault with intent to murder. The corporate testimony from, James Crawford, he was stabbed in the neck by a defendant. And I would point the court, directly to people exhibit number 6, at the very bottom. I believe that the exchange, between the defendant and, Ms. Connell, it helps support intent, it goes to the defendant's intent to kill. At the very end of that page of People's Exhibit 6, there's reference to, I'm offing him soon, any expletive, and the name James is included in that text message. I believe that goes to support intent as to count one. Respectfully, Your Honor, I would submit to the court that the people have carried our verdict here at exam for count one. As count two, as suspected, I'd be moving to bind over on an attempt home invasion first, as opposed to regular home invasion first. There was testimony about the lock being broken and the door being popped off. I again would direct the court's attention to People's Exhibit 2, as well as 3 and 4, where there are multiple references by defendant in that exchange about blowing the door down, about coming inside the house, about things of that nature.
Yeah, that's not an element of 2. You're talking about count 2.
Yes, count 2.
That's not an element of count 2.
Attempt, Your Honor. I'm asking for attempt. So I'm just basically, my argument is to attempt. As the court knows, there has to be some type of beyond a mere plan to do something. There has to be some type of action to go beyond for an attempt. And I would submit to the court that based upon the text messages and the defendant's actions of kicking the door, as well as the door being whatever the phrasing was in the testimony, popped off, or the lock being broken, that was the action that went above and beyond the plan to break into the house. So with that, I would submit to the court that that supports the attempt. Now, the theory of the home invasion, I would submit to the court and ask for bind over on with the intent to commit an assault therein. In People's Exhibit, excuse me, I apologize, Your Honor. People's Exhibit 5, there is an exchange about see you tomorrow, coming to bend you over and nut on you and leave to pick up some money I'm owed, and that's that. I would submit to the court that that is the intent to commit the assault on Ms. Connell, as well as there is some threats in there about keeping a pistol nearby. So with count 2, I would move to bind over on an attempt, not the regular, but an attempt home invasion first. As to count 3, Your Honor, the court received People's Exhibit 1, A, B, and C regarding the served personal protection order. Regarding the dates on there, I know the court saw all of that. And in regard to the count that I indicated to Mr. Konecki and the court that I was going to ask the court to bind over on, that would be the PAT code of 752.797. 3, D as in David, computers used to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. And I would submit to the court that based upon probable cause, there is enough to indicate that a trier of fact is up to them to determine whether or not the defendant sent those messages by way of text. In the statute in MCL 750.145D, it lists a cellular device as being a quote unquote computer. So with that, I believe there's enough evidence on the record and enough evidence based upon the admitted exhibits, the text messages, to support bind over on an additional count 4 of the computers used to commit a crime. And with that, Your Honor, I would just reserve any further argument below.
Your Honor, let's start with count, which I think would be now count 3, the aggravated stalking. We object, simply no argument with regard to that. As to the home invasion or the attempted home invasion now that's being requested, I still would submit to the court the testimony that we have before the court is that the door was kicked, that the door lock was damaged, but at no point did he go in. At no point did a witness say He tried to go in, he attempted to go in, he walked towards the door, he walked towards the apartment, he walked in, he walked near it, anything, no testimony whatsoever with regard to that. I believe that the home invasion count, whether it's the home invasion, the 10th home invasion, first degree, that count should be dismissed. I would argue with regard to the assault with intent to murder that they have not established my client's intent. As the court heard the testimony, there was a struggle in the hallway. As far as the intent, I don't believe the people have met their burden. And then I would simply object no argument with regard to the computer count for the computer count they're attempting to add.
No, Your Honor, unless the court has any questions, I'm happy.
All right, court, having heard the testimony, argument is as follows. The court heard from James Crawford that on January 30th, 2023 at 2258 West Grand Boulevard, his apartment, he was there with his son's mother, who is Destiny Connell, along with the other kids that live there with her. That he heard a knock on the door, that he went to the door. There were no, he saw who was there, the defendant was there, with no words exchanged, but he didn't close the door. The defendant then kicked and yelled obscenities, started kicking the door until the door broke, or the lock broke and the door was going open. He then confronted him. They were in the hallway. When he went in the hallway, that Desmond closed the door behind him. That he swung at him, or attempted to punch him, or swung at him twice. He did not connect. The defendant then started stabbing him in the neck. The defendant never came inside the apartment. He then ran down the hallway, keep him away from the apartment, and proceeded to chase him, and then continued to attack him once he got to the elevator and the stairwell. Spent 3 months in the hospital and rehab because of the injuries. I heard from Destiny Connell, who testified the same date, same location. The defendant is her daughter's father. Testified regarding receiving a stream of threatening messages from him, which are exhibits 2 through 6. Also have exhibit 1, which was also admitted, which is the documents related to the PPO against the defendant. And in relationship to exhibit 2 through 6, they're just listed as person on the dummy. She testified that that's the name that she has the defendant listed in her phone under. And that those were the text messages that he sent and she responded to. Also that she's approximately 8:52, there was a knock on the door. And it was defendant, she was still receiving text messages. That Crawford went to the door, answered the door, then closed the door and walked away. Kicking and banging on the door ended up coming popped open. James, Mr. Crawford, then met the defendant either at the door that she said that she described it as them colliding there. And she pushed the door closed and she was terrified. She heard running, heard groan as James came in, he was bleeding from the left side of his neck with blood everywhere. The police had been called previously, but police and EMS initially came. As to count 1, for a fine question of fact, due to the actual assault that occurred, the location where the defendant was hurt, the defendant initiated the use of a weapon in this case. Home invasion 2, not 2, count 2, which is move to attempt home invasion. Court's going to also find that there's also a question of fact that, due to the text messages, and it was saying that he kicked the door in. And neither party said he actually came in the apartment, but that's because according to Miss, Powell, I'll get her name right. That's Miss Powell, that, Mr. Crawford, we met him at that, right at the doorway, and they collided together and ended up on the outside of the door, outside of the apartment. As to count 3, aggravated stalking, with the text messages, with the PPO, and with this incident, we're finding with more than enough repeated and continuous harassment of Ms. McConnell to bind over on that. And then last but not least, as to count 4, which is the use of computer to commit a crime, and looking at the threats that were done after the PPO was in place. And in light of what happened, he threatened to come kick the door in. He did. He threatened to come assault Mr. Crawford. He did. Or finds that it becomes a question of fact as to all. Or finds that those felonies did in fact occur in the city of Detroit. Proper cause of which the charge is defendant will be bound over to the Wayne County Circuit Court's Criminal Division for arraignment of the information. Give you the date 1 second. The date's gonna be 6/14/2023. Mr. Williams, you do understand that there's no contact provision. I assume you've been abiding by it because there's no issue that's been raised to it.
Yes, sir.
Your Honor, if there is an opportunity for me to just briefly address bond regarding that.
Go ahead.
I shared this with Mr. Konecki ahead of time. There was a text message that the Ms. Connell received. She briefly brought it up, but however didn't get into it when she testified the May text message. That would be this May, where the body of the message is, if you don't have my daughter contact me or see me, James will be dead by the end of this month. Nobody will be dead by the end of this month, promised. And I will get away with it like I already proved to you. I need to hear from or see my daughter. Understandably so, the victim was very concerned about that, very fearful regarding that. There was a lot of specificity in this message regarding a daughter. She testified that she didn't have a daughter with anyone else. The phone number, and I'll just as an offer proof to the court, it's not a listed phone number for defendant. She readily, she being Ms. Connell readily told me that. She is concerned that he's using burner phone numbers, the apps to send stuff to her. I would ask the court to increase or revoke bond. If the court is unwilling to do that today.
I need her back in.
I'm sorry?
I want to hear from her. I need her back in.
I'll go get it.
You want her right here?
You go to the other side. You've done that.
Well, she's
You
gotta
gotta
be by
speak up.
microphone for,
You
well,
gotta
she,
make sure you speak up.
yes, sir.
All right, Connell, you received a text message from somebody in May?
Yes.
Okay, when you started to say something about it in the you're testifying. I think I cut it off. But anyway, when was that? It was May of this year, correct?
Yes, May 1st.
Okay, and recognize the number it came from?
No, I assume it was one of those random numbers that he gets.
Okay, when you say he gets, you're talking about the defendant?
He, yes.
Yeah. Well, how do you know it was from him?
Because of the things he said regarding, James, I want to see my daughter. He was basically saying in the message, like, if he don't see his daughter, he gonna hurt James, like, he gonna finish the job and, oh, I can get off with it. Because, you know, he's so cocky during this whole process, like, yeah, see, I can do this and the nigga in the hospital can't walk, can't talk no more, like, bro.
Your Honor, none of that is in the text, just one text.
No, but this is what he's
Some
saying.
of that is in the text message, the
So-
last part is not.
That's my-
I agree, okay. You got any questions you want to ask based on my question?
Just that you don't recognize this phone number, correct, ma'am?
No, because.
And then the information that is in there, it's not a secret that you and Mr. Williams had a child together, correct?
No, it's no secret.
And it's
at all.
not a secret that there was some incident that led to Mr. Crawford being injured, correct?
Exactly.
So, many people are familiar with, this incident and there being an issue between everyone. Is that fair to say?
Yes.
Thank you.
Just one or two questions, Your Honor, and I know you testified already, but you don't have a daughter with anyone else?
No.
Okay.
Feel free to paternity test her. She's
All right.
his, unfortunately.
Thank you, ma'am.
Your Honor, just that this text message isn't from a number. She has a number associated with Mr. Williams where there was a listing of a number of texts between them that went on for, a period of days, several texts. So probably, I couldn't even count the number. Dozens, if not more. This one from a random number has information in it that anybody who knows these people has this same information. It's not like there's some sort of secret information in this text that it clearly points to somebody who has intimate knowledge of it. It could be anyone that is involved. It could be somebody on.
If I don't see my daughter, that's not intimate. How more intimate can you get?
Anybody can say my daughter because they know there's a daughter. They know they have a daughter in
No.
town. Mr. Williams has indicates he has never been associated with this phone number. He has not sent this text message. He has not had contact with him, and he's not had contact with his daughter since this process began. Mr. Williams has been staying away. I know when we originally appeared, I want to say somewhere in March, we came and Ms. Connell was the only one that testified. The court took an opportunity to explain to Mr. Williams what would happen if there was texting, if there was messages, and Mr. Williams did not do any sort of texting, any sort of violation. If this text did come, he was not under a no contact order. It would be potentially contact as far as if the PPO was still in place, but the court case against him was dismissed in April at the circuit court level so that they could reinstitute the charges and start with Mr. Crawford. So there wasn't a no contact. Even if the court believes that that was him, although we are indicating that he has nothing to do with that text message, he understands that there's going to be no contact. And I would indicate in the time that I've known Mr. Williams from this case beginning through now, he's had the same phone number and he's contacted me the same way each time.
Your
Honor, in regard to the message, it's very specific, and I think that based upon what is on the record and what's on the record in terms of admitted exhibits, both of the witnesses, both the female witness as well as the male witness, they have a legitimate safety concern. The female witness, there's.
Well, let me just say this. The problem is, she said that message was from May 1st. He wasn't arraigned until May 5th. So there's no violation of any order because he wasn't given one until May 5th.
Understood, Your Honor, understood that, yes, so I didn't know that, I didn't know that he was rearranged on, you said the court to the fifth.
Yeah, May 5th. He wasn't arraigned on the matter until May 5th.
So I can't then ask the court to revoke bond because exactly, there's not a, order in place. However, I would ask the court to increase bond. I think that that's a fair request based upon this very specific, very threatening text message, based upon severe safety concerns. The defendant knows where these people live. I understand that he's on tether, but if the court knows that, it doesn't stop things necessarily. So I think that our increase in bond is a fair request. I would respectfully ask the court to increase the bond.
Judge. No. Our motion, your argument, her rebuttal, it stops. I don't go back and forth. At this point, I'm not gonna increase it. I'm not gonna do anything with it. But Mr. Williams,
Yes, sir.
I want you to know how close you came. I was ready to lock you up and make sure, not only lock you up, but I'd have sent you over to Wayne County and make sure that you had no phone privileges, no nothing. You couldn't talk to anybody except this man right here.
Yes,
Do you
sir.
understand that?
Yep.
You have no contact whatsoever with these folks.
And I remember.
Your family, friends, whatever. I don't have control over them. You have control over you. If I so much as think of someone that's related to you, associated with you, or whatever, has contacted these folks, I'm taking it out on you. I'm letting you know that now. I don't care what your attorney says. I don't care how much he fusses and argues about it. I'm gonna do it. Do you understand that?
I understand.
No contact whatsoever. You put nothing about this on any form of social media. Do you understand that?
Yes, sir.
Right.
Thank you, Judge. Have a good day, everyone.
Oh, did I need a date?
Yeah, 6/14.
Okay.
All right, thank you, Your Honor.
Oh, Your Honor, may I approach the exhibit?
Yes. Okay.
Six is gonna be.
Okay. Judge, I'm sorry. Mr. Williams just brought up with regard to his tether, I think when it was put on, it was not given hours, so he's technically on house arrest. But you're working, correct?
I am working, and I do have a girlfriend.
We're hoping we can get the court to give hours that will allow him to work. What is your schedule?
I gotta have some documentation showing the hours. You know, give me the documentation, I'll consider.
And Your Honor,
allowing you
maybe
to go
we
to
can
work.
address that in circuit court, or if the court wants to address it before.
I have control over this case until the arraignment. date.
Understood.
You give me your work schedule, I'll email it in, and we can set up a Zoom to discuss that. Thank you.
Okay.
Thank you, Your Honor.
All right, thank you, thank you.
All right, so there's,
Hamilton.
Hamilton.
You gotta take it out here anyway.
You have to give them a turn. Okay.
Huh?
You have to give them a turn.
Nope, they didn't,
Oh, man.
and I think he's, oh, no, he's still on, okay. I'll call one of those calls. I think this is the case. Jamal Hicks. You ready, Kim? Parties ready on Jamal Hicks. Calling case number 2356841, the people of the state of Michigan versus Jamal Hicks. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Habitual offender for notice. This matter is scheduled for exam. Defendant has failed to appear.
Philip Henderson on behalf of the people, we are under P86029, and we would ask for a date in this matter. We motion for a date.
Good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Jamal Hicks. I've not had any communication with him. I don't have a number, or a trust.
All right, take this up again, any volunteers to submit should be forfeited, the bond says 30,000 cash.
30,000 cash, Judge?
Yes, 30,000.
Yes. Is Thompson still on Zoom?
It's been reassigned. I've made it clear
No, that's
to
what I
to you that my PCCs are at 8:30. We don't hear from you, I'm gonna reassign it.
understood,
Somebody
Judge.
else.
I just had it down for a different day, and so I totally understand.
All right.
And,
What are we doing now? Oh, Jordan and,
Yeah, Richard Jordan, what happened to that?
I think the prosecutors asked for an adjournment.
Okay, Mr. Richard Jordan, step it up. Step behind me.
Where's Smith? Oh. I'm saying the attorney who put me off last night.
I tried.
Did you?
Yes, I
Well,
did.
they can find you. Oh, I see.
Yeah, and that's why I said I thought that.
Okay, well, thank you. I appreciate it.
No, that's.
Yeah, that's. Thank you, I appreciate it. All right, you ready, Kim? Yes. Calling case number 2356848, the people of the state of Michigan versus Andre Richard Jordan. Defendant number 1 is charged with count 1, assault with intent to murder. Count 2, weapons, firearms, discharged from a vehicle causing injury. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation. Count 6, assault with a dangerous weapon, felonious assault. Count 7, count 8, count 9, weapons, felony, firearm. Count 12, weapons, felony, firearm. The people of the state of Michigan versus Danielle Smith Jr., defendant number 2 is charged with count 1, assault with intent to murder. Count 2, weapons, firearms, discharged from a vehicle causing injury. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation. Count 4, weapons, firearms, possession by a felon. Count 5, weapons, ammunition, possession by a felon. Count 6, assault with a dangerous weapon, felonious assault. Count 7, count 8, count 9, weapons, felony, firearm. Count 10, count 11, count 12, weapons, felony, firearm. Habitual offender, third notice. Matter scheduled for exam.
Good morning, Your Honor. Lauren Yerstessian on behalf of the people, P67104.
Good morning, Your Honor. Stephanie Carson on behalf of defendant Andre Richard Jordan, P57096.
Good morning, Your Honor. I'm Attorney John McWilliams, P17565, on behalf of Mr. Donnell Smith Jr. Good morning.
Morning. You ready to go forward?
No, Your Honor.
I'm sorry, go ahead.
No, Your Honor, the people are not ready to go forward. The complaining witness in this matter was shot as a result of this offense. And my information, in speaking with the officer in charge, is that this victim is still having difficulty walking, so much so that at this time, like even picking up the defendant, even picking up the complaining witness at this time is difficult. So Your Honor, I'm asking for an adjournment for 2 weeks.
Yeah.
And what is 2 weeks gonna do?
I'm hoping to allow him some more recovery time, Your Honor.
Yeah, just for the record, this shooting allegedly happened on May 8th. It was a through shot to the ankle. And if he was having difficulty walking, they could have made some arrangements, got him a wheelchair. My client has been in custody since May 8th. I would object to the adjournment.
I'm here, Your Honor, on behalf of Daniel Smith Jr. I've had my discovery received, have reviewed it, I've made a valiant attempt to send the discovery to Ms. Carter last night. Carson, but I understand it didn't arrive, probably from some technical issue that I might have had with my equipment. But I had the discovery package some time ago and have seen my client at the Wayne County Jail either once or twice. And I understand the situation. I'm here and prepared.
Yes, sir.
I hear the matter dismissed.
Thank you.
That's without prejudice.
Understood, Judge.
Step this way, sir, gentlemen.
Ms. Carson,
Yes, sir.
we need a form filled out, please.
Okay, I'll take care of that.
There you go, ma'am.
Williams, I need a form filled out.
Thank you.
All right, then I guess we're ready on McBride. McBride is a hold, Judge.
Hey.
How are you?
I'm good, how are you?
Good to see you. That's a history.
What?
So that's why you want to speak English.
Yes.
No, that's the-
Yeah. Oh.
Yeah.
Excuse me, I'm sorry to interrupt, but I have a question.
Mr. Thompson, we had called to get you a new attorney assigned. And so far, we haven't heard from anybody, so we're trying to get with them now again, and see who they're sending. All right?
Okay.
Either that or put it over till tomorrow. You know, I just didn't want to do that because I know you've been on all morning. All right, so I'll just wait for the attorney.
I don't know, but
Now, if you would prefer to put it over tomorrow, I'll put it over tomorrow, then we'll have someone here by then. What were your?
I want to put. I'm sorry.
What would your preference be?
I know we don't have to push it over till tomorrow. I just was wondering if I was supposed to just still sit in here or not.
Yeah, yes, please, if you just, that way you get a chance to talk to the attorney. All right, hold on, just hold on, as soon as we get one, we get you back in, all right?
All right.
All right, thank you.
Parties ready on Shamika McBride. Calling case number 2355654, the people of the state of Michigan versus Shamika McBride. Defendant number 2 is charged with count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams.
So,
Matter scheduled for examination.
Philip Henderson on behalf of the people, 86029.
Good morning, Your Honor. Sophia Nelson of Neighborhood Service on behalf of Ms. McBride, 277960. Ms. McBride is present here in court with me today. Ms. McBride, please state your name for the record.
Shamika McBride.
We're ready to proceed, go.
We are ready.
Judge, there's an attorney out, Mr. Thompson.
There's an attorney.
Yeah, Rita White.
Huh?
Rita White. She's out.
You're gonna stop, we're gonna do another matter real quick, PCC.
Ms. White, you ready?
Ms. White? Let's do this then. Do it. First witness.
Yes, Your Honor, the state calls Officer Orovitz to the stand.
Timothy, Timothy, last name Oravets, Oravetz.
Just right here, right here.
Hold on one second. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, you can close the door towards you. See, please. Go ahead.
Good morning.
Good morning.
Could you please introduce yourself to the court?
Officer Timothy Oravets, badge 15,
And where are you employed?
the Detroit Police Department,
How long have you worked there?
about 8 years.
And were you working on February 18th, 2023?
Yes, I was.
Yeah. Did you have the opportunity to be at 3752 Crane Street?
Yes.
Is that in the city of Detroit?
Yes, it is.
Yes. While you were there, did you have a chance to come into contact with the defendant in this case?
Yes.
Could you tell us how that began? Or why were you there?
I was executing a search warrant at the location.
Okay, and during the course of that search warrant, what did you collect that pertains to this case, if anything?
Yes, there was a black purse underneath a table in the kitchen area. It was open. I could see a bunch of money sticking out of it. So I recovered the money from the purse, as well as there was a lotto fold that had 2 rocks of crack cocaine inside that purse also.
Did you find out who the purse belonged to?
Suspected crack cocaine.
Yes.
Yes, sir, suspected crack cocaine. Did you find any, were you able to identify the owner of the purse?
Yes.
Okay, and how did you do that?
There was a piece of mail inside the purse with the defendant's name on it, as well as the address of the location we were at. She also advised me that it was her purse.
And when you, let's be clear here, you said it had the defendant's name on it. I'm asking you about Shamika Deshawn McBride. So whose name did it have on the paperwork?
Shamika McBride.
Okay. And did you come into contact with someone that night that you could identify as Shamika McBride?
Yes, I did.
Do you see her in the courtroom here today?
Yes.
Could you point her out and identify an article of clothing?
She's seated behind you with a white shirt on.
Your Honor, if the record reflects that he's identified the defendant in this case.
Record so reflect.
Okay, you said that you collected suspected crack cocaine. What did you do with that?
I took possession of it and later on transported it to our narcotics PPU where it was placed on evidence.
Okay. Before it was placed on evidence, did it ever leave your possession?
No.
Okay, when you say placed on evidence, what is that?
We take it down to our narcotics unit, they test it, and then they test it in front of you, and then it goes into the lock seal envelope.
Okay, do you know who tested?
Yes.
Who's that?
I don't know his rank, I think he's a Corporal Rhodes.
Okay. Did it ever leave your possession before you gave it to him to test?
No.
Okay. Nothing further at this time, Your Honor.
This home, there was a search warrant for this house,
Yes.
and you reviewed that warrant prior to executing it?
Yes.
And the subject of that warrant was an Eric Howard or AKA Lou Mack.
I don't remember who the subject was.
Would, reviewing the warrant refresh your recollection?
Yes.
What's the relevance?
Your Honor, I'm gonna ask more questions to go into the, breadth of the warrant, but I don't believe Mr. McBride's purse is covered by the warrant.
Doesn't matter.
Does it matter?
No, it doesn't matter. She was at the location when they executed the search warrant. If she doesn't own that house, then she has no argument regarding the search warrant.
She was a guest who has,
Then she has no standing to challenge the warrant.
I'm not challenging the warrant, I'm challenging what was covered, the
Again,
scope.
she has no challenge. She has nothing to challenge the warrant with.
I'm not challenging the warrant. They had the right to enter the house. What I'm taking issue with, she has a, expectation of privacy in her belongings as a guest in the home. If the warrant doesn't detail,
Not when her purse is wide open.
they had to search the purse.
Excuse me. The testimony was that her purse was on the floor, it was wide open, and the money and the suspected crack was in clear view. Excuse me. Do not interrupt me again. That's the testimony that I heard. And you want to question that testimony, you have a right to.
I will. You observed, the purse, correct?
Yes.
And you searched it, one time and only recovered money, and you had some questions about whether or not you could, still ask the court for that money, correct?
No. Can you rephrase that?
Okay, the first time you noticed the purse, all that you observed in the purse was money, correct?
Yes, I recovered all the money out of the purse.
And at that time, you had not found any drugs.
I don't remember.
Would watching your body worn camera refresh your recollection?
Yes.
May I approach, Your Honor?
No. If you're gonna put something on, you have to put it on Zoom.
Okay.
That's how it works. Your screen has been activated, so you can put it on.
Do you recognize this?
It appears to be my body camera.
Going forward, you were in the home for quite some time, correct?
Yes,
And when you first entered the home, you came into contact with 13 different people,
yes,
and they were all ordered outside immediately
correct,
at gunpoint.
yes,
And they weren't given an opportunity to collect any of their belongings.
correct.
And they were all handcuffed.
I don't remember if they were all handcuffed.
And they were detained.
Yes,
And first you conducted a search of the home, correct?
yes,
And you located a locked closet in a bedroom, correct?
I don't remember if I located that, but I know there was one in there.
Yes. And in that closet, there was drugs and guns.
Can't testify to that.
Did you observe whether or not there was a closet with guns and drugs in the closet?
Yes, I believe I did observe that.
Okay. And there were identity documents recovered in that room that belonged to the subject of the warrant, correct?
That I don't know.
Okay. And it was after all of this that you decided to look at the purse, correct?
We finished searching the house, yes.
Okay, so you searched the house, the subject of the warrant and the items that were sought in the warrant were recovered. The warrant was for drugs and guns, correct? And scales?
Yes.
Okay, and all of those items were located and recovered?
We searched the whole house at the same time. We don't go, does that make sense? So I
I'm
don't know
saying
when-
before you started looking in the purse, the items that were in the closet were determined and seized.
That I don't know.
Okay.
I don't know the timing.
You still have to authenticate the video, please.
He identified it as his.
He did not identify it. He
Okay.
said he didn't say it was his. He said he thinks it's his. He didn't identify it, so it has not been authenticated.
You recommend this?
Yes, that's my body cam.
That gun comes back to somebody from Canton. It's not stolen, so. Can we take?
Sorry.
Can we take? It's not stolen, so. So. Can we take? I mean.
It's with the note, yeah. I mean, it's in the house on the note.
Because like her purse is full of money, but before I even waste my time trying to count it, if we.
Okay, well, you gotta turn the sound off on your system, and let's play through the. That's why we're getting all that feedback.
Maybe it's because mine's on. Might be because mine's on. I've got it on mute, but maybe I should.
At this time, I'm using it to refresh his recollection.
Turn it off for a second, please. Please turn the sound off. What's your objection?
I'm objecting to her publishing it to the court because she hasn't moved to admit.
Using it to refresh his recollection here. As to what the order of, whether you had to search the person in order to find the drugs. Wasn't in plain view.
Okay. What difference does it make? Tell me. Give me, I'm gonna say offer
I'm
proof.
sorry.
Because there was a warrant to search this home. The purse was in the home. They can search everything in the home. Doesn't matter if it's her purse, John Gold purse, or President Biden's purse. Doesn't matter. He can search everything in that home.
There's case law that establishes that people have a right of privacy in their possessions in a home if they're not identified in the warrant as the subject of the warrant. An individual was the subject of the warrant. All items that were subject to the warrant were seized prior to the first even being looked at. She has a reasonable expectation of privacy as a guest in the home, of which to her item that clearly belongs to her. He found an identity document in the purse before he found the drugs.
I don't agree with that. I don't agree with no, not at all. She doesn't. It's not her home. I'm looking at it. Because this is, let me make sure, I don't wanna speak out. This is the house that was the subject of the search warrant, correct?
Yes.
I'm asking them, you can testify.
Yes, Your Honor.
Okay. No. I mean, no. No conflict. On to something else. You could address it across the street. You disagree with my ruling. But no. It's a drug house. From the looks of it.
When you first searched Ms. McBride's purse, all you located was money, correct?
I don't remember.
And then you decided to bring Ms. McBride back into the home to interrogate her, correct?
Yes.
And this is because you had found paperwork in the purse with her name on it?
You're asking if that's the reason why I chose to interrogate her?
Yes.
I don't know if that's the reason why I chose to interrogate her. I'm not sure.
So there was a conversation briefly in your body on camera. You were asking your superior whether you had authority to civil asset forfeiture the money that you saw in Ms. McBride's purse, correct?
Yes.
And then you found an identity document in that purse, and you wanted to speak to the person who owned the purse, correct?
Yes.
To try to get some more information to decide whether or not you could civil assets forfeiture that purse, correct?
We were trying to determine her connection to the location.
Right, and you wanted some reason that gave you the authority to seize all the cash that was in the purse.
We were trying to talk to her about what her relation to the house was.
Right. And at that time, the weapons and narcotics had already been removed from the closet, correct?
I believe so.
Yeah. And you are familiar with the statement form that you have people who are subject to interrogation fill out, correct?
Yes.
And on that form, you wrote non-applicable intoxicated, correct?
Yes.
And Ms. McBride was actually transported to the hospital from the scene, correct?
Correct.
Due to an overdose?
I believe that's why she was taken.
In fact, you wrote stated high as your reason for why she couldn't be questioned.
Yes.
But in fact, and she was obviously under the influence at the time you were talking to her?
Not at the time. I believe later is when the effects of the narcotics began to set in. She began like falling out. That wasn't until later.
Okay. And the reason that you have to ask about whether people are intoxicated is because it goes to the voluntariness of the confession, right?
Asking for a legal opinion.
Are you aware in your training whether or not it's relevant into an interrogation as to whether someone's intoxicated?
Yes.
Okay.
And you're aware that you're not supposed to question people who are actually under the influence?
Correct.
Okay. But in fact, despite her repeatedly telling you that she was under the influence, you interrogated her for over 20 minutes.
I believe we were talking to her. I wouldn't say we were interrogating her then. Once she said she was under the influence, we finished the interrogation. You
So-
can't use any of that information.
So immediately when she was brought into the house, she told you that she was under the influence of heroin, correct?
I don't remember.
And it was, you continued to ask her questions for 20 minutes.
Yes,
Okay. And those questions were about the contents of her purse.
I don't remember.
Okay. And it was during that 20-minute interrogation while rifling through her purse that you finally found that lotto fold, correct?
Yes,
And so, you were asking her questions about the money and her connection to the house,
correct.
and you were doing so after she already told you that she was high.
I don't remember.
And then while you were interrogating her while she was intoxicated, you said, oh, Shamika, things are bad for you when you finally found that lotto fold after about a 15-minute rifling through the purse.
I don't remember that.
And it was at that point that she was placed under arrest.
I believe she was arrested before that, if I'm not mistaken.
She
I believe
wasn't
she
just
was in
detained?
handcuffs.
So you were interrogating her while she was in handcuffs on the scene under arrest?
I don't remember.
Okay, so you're saying you believe she was in handcuffs and under arrest, but you also don't remember?
I believe that she was in handcuffs when she exited the house. I don't remember when we were questioning her if she was in handcuffs or not.
Okay. Was she read her Miranda rights?
She was.
By who?
Police officer Dodd.
And were you present during that?
I was not.
Okay, so you don't actually know whether she was read her Miranda rights?
No, I know he told me that he did.
No further questions.
Nothing further from this witness at this time. And the state calls Corporal Rhodes to the stand.
Leo, Rhodes, Rhodes.
You swear or affirm to tell the truth, whole truth, and nothing but the truth.
I do.
Yeah, see?
Good morning. Could you introduce yourself to the court, please?
Detroit Corporal Leo Rhodes.
And Corporal, where are you employed?
Narcotics section.
Of DPD?
Yes.
And how long have you worked there?
I've been in narcotics for probably 15 years.
Have you tested drugs before?
Yes, I have.
And have you received any specialized training to be able to conduct those tests?
I've had tests with the True Narc machine, yes.
Okay, did you receive training on how to use that?
Utilize, yes.
And have you tested drugs with it before?
Yes, I have.
Approximately how many cases would you say you tested drugs?
Over 100.
Okay. And did you come into contact with Officer Orovitz regarding this case?
Yes, I did.
Okay, and what happened when you saw him?
He brought some suspected drugs tested.
Okay. And what did you do with those drugs?
I used the True Narc machine, analyzed it, and it produced the positive results for cocaine.
Did you weigh the drugs?
Yes, I did.
And do you know the weight?
1.8 grams.
Nothing further from this witness.
Are you aware of the false positive rate for the True Narc machine?
No.
Are you aware that studies have shown that the True Narc machine only produces
replicable results about 68% of the time?
I'm not aware of that.
Do you have any background in forensic science?
No, I don't.
Are you a qualified lab technician?
No, I'm not.
Have you received any degrees or other education that would allow you to test drugs for the Michigan State Police in a lab?
I don't work for state police, so I don't do anything.
You're aware that we have a forensic laboratory through the Michigan State Police?
Yes, once I do a preliminary test, then we transfer it over to the MSP lab, who does another test to confirm whether or not it's what the drug is.
Okay, and so this test that you did is a preliminary test?
I did a preliminary, that forensic test is a secondary test.
Right, and so, and you have no idea how?
Let them answer the question, and then you get to answer your next question, please. You gotta let them answer the question.
Yes, sir.
Thank you.
You have no idea how accurate TrueCan is, TrueNarc?
Always known it to be accurate every time. I've never seen it not be accurate.
How do you know whether it's accurate?
Well, I'm familiar with narcotics as well. I've been at narcotics for 15 years, so I've rated for 13 of those years. So I've had contact with narcotics for the last 28 and a half years with drugs.
So you're assuming it's accurate because what you think is drugs is testing positive for drugs?
Yes.
Okay, so you don't know if what you think is drugs is actually some other substance and it's testing positive?
It's when I use the TrueNarc machine or I use a test kit, it confirms whether or not it is a drug.
Right, so you believe it's accurate because what you think is drugs is testing positive as drugs?
It is testing positive as a drug, yes.
Okay, but you've never looked into any of the evidence as to whether or not TrueNarc is actually accurate?
We use it because it's supposed to be accurate. I don't know how often we have a negative, but it's always been positive. I never had any problem with it before.
So you're not aware of whether there's ever been any false positives?
That's correct.
Okay, because you've not looked into any of the empirical research as to the accuracy of TrueNarc?
No, I haven't looked at it.
And so you're assuming that it's accurate because you've been told that it's accurate?
Yes.
And so you don't know how often a preliminary.
Counsel, I've allowed this, at least I've heard it like 3 times already.
Okay.
I don't need to hear it anymore.
Nothing further this time.
Thank you.
Your Honor, at this time, the state rest.
Any witnesses?
No, Your Honor.
Argument.
Your Honor, there was a search warrant for the house on the day in question, when Officer Orvis was executing the search warrant, found the purse, he was able to identify from it cash, which is what they were looking for, drugs, which is what they were looking for, and also paperwork that indicated who the purse belonged to. And he found that person on the scene, and it's the same name, the same address, and Your Honor, that's sufficient to meet the probable cause standard in this case.
Your Honor, I rely on People versus Burbank, 137 Mich. Act 266, 1984, that says a warrant authority for search of a home does not authorize the search of the guests or their belongings in that home. I wasn't able to get into it in depth, but what happened in this case is that there was a warrant for a particular drug dealer, Lou Mack, and that warrant detailed guns.
You didn't get into it in this case, right? So it's not on the record. So how can you argue something that's not on the record?
Well, I would.
You can't.
I do not believe that the officers had authority to search Ms. McBride's purse. They did so under an unlawful interrogation while Ms. McBride was intoxicated. And for those reasons, I would ask that the drugs be suppressed and find over be denied.
Here you go.
Your Honor, I have any more.
Well, her, the defense argument that there should be, the drugs should be suppressed.
Oh, yes, Your Honor. Well, the there was not a reason, I apologize, there's not a reasonable expectation of privacy within the home. She was there, the officer testified that he saw it when he first encountered it, he testified that he saw, the drugs and the money. That creates an issue of fact, that should be heard by the Third Circuit.
I would disagree.
No, you don't get another argument. You get your rebuttal on this not.
Okay.
All right. Court having heard the testimony, arguments, findings as follows. 21823 in the area 3752 Crane Street in the city of Detroit. Officer Orbitz was there executing a search warrant that he located that there were at least 14 people removed from the home. They were all brought out and detained. There was narcotics and guns found in a locked closet in the home. Officer Orbitz also located a black purse under the table with money sticking out of it. He then found mail in that purse with the defendant's name on it. He then had a conversation with the defendant. I'm not going to take the conversation whatsoever into consideration here because it appears that the defendant was definitely under the influence of drugs. We don't have any accurate information regarding whether or not she was given her Miranda rights. You know, your witness was told that. Well, she did or she was. She didn't. And what condition she was when she was given it. So any statement she made, based on their questioning, I'm not using this. However, also we heard from Corporal, he did testify that he took money and eventually took 2 lotto folds with suspected crack. That he maintained control of that until he got to narcotics, where he turned it over to Corporal Rose, who tested it and tested out to be positive for cocaine at 1.8 grams. Based on the facts that I heard and circumstances, I don't find that the defendant had a right to privacy of her purse. That purse was in the location that was being searched due to the warrant. I don't have anything on this record that would challenge the warrant itself. It's going to challenge the 4 corners of it, and that wasn't done. That the warrant itself said they were looking for money, drugs, guns, and paraphernalia. The purse was open. The money was in plain view. They wanted to investigate further her connection with it. They found the drugs inside the purse. That's possession. Court finds that that felony did in fact occur in the city of Detroit. Probable cause is charged as defendant. Shall be bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be 6/14/23. 9 o'clock. All right, we have Sergeant here.
He's checking to make sure if she's out there.
We could do the, PCC, Judge.
Oh.
PCC.
No matter, I mean, do PCC, we can do. I have a couple more minutes.
Sure. Oh.
Okay. All right, let's do PCC then.
You ready, Kim? Yep. Calling case number 23-56763, the people of the state of Michigan versus Andre Thompson. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Rita White on behalf of Mr. Andre Thompson. He is present. Mr. Thompson, please unmute, activate your video, and state your name for the record.
Hello, Andre Thompson.
Philip Henderson for the people, P86029.
You set this matter for exam.
Your Honor, I am new, just recently appointed, and I am without discovery. I was just requesting, if possible, we could schedule this for another PCC so I can obtain discovery and further discuss with Mr. Thompson our options of how we're going to proceed.
Okay, I'll adjourn the PCCs. I'll make sure you get discovery so you have more than enough time to do what you need to do with it.
I'll send it today.
All right, and the prosecutor said he will send it to you today.
Okay.
But if you don't get it, just make sure you send in a discovery order to the court. I can act on my order.
Will do.
All right. All right. June 7th at 9:45.
I'm sorry, June 7th?
Hold on,
Is
Mr.
10
Thompson. I beg your pardon?
Is
I'm
10
sorry.
a.m. a little is better? Because I have a bunch in the morning matters.
All right, 10 o'clock. June 7th at 10 o'clock.
Okay. And I'm sorry, I didn't give the prosecutor's name and or P number.
It's Philip Henderson.
Okay.
Philip Henderson, P86029.
Thank you. Okay, thank you, Your Honor.
Thank you. Did you get a chance to talk to Mr. Thompson?
Yes, I have. Yes.
All right, so Mr. Thompson, that's 10 o'clock, June 7th, that's in person.
10 o'clock, June 7th, in person. Okay.
Yeah.
Oh,
Or is it
I thought the
court?
court was going to adjourn the PCC to June 7th, or
No,
is it going to be
that's the exam, June 7th. I don't adjourn PCC, there's no reason to.
Okay. Okay, thank you, Your Honor.
All right, thank you.
Okay, take care.
So Sergeant didn't show up, right?
Attorney Nelson, was you?
Mr. Phillips.
Attorney Nelson.
Yes.
Trying to read it?
She
Sergeant
was.
did not show up.
Oh. Calling case number 2255024, the people of the state of Michigan versus Robin Sargent. Defendant is charged with count 1 and count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for examination. Defendant has failed to appear.
Philip Henderson for the people, P86029. We would make a motion for cases.
Good afternoon, Your Honor, Sophia, or still morning. Sophia Nelson, Neighborhood Defender Service, on behalf of Robin Sargent, P77960. I would ask for the 48-hour period for the sergeant to voluntarily.
There is no 48-hour period. Your client is not here, right?
To my knowledge, my client is not here.
All right. The case Bishop, any bond previously submitted shall be forfeited. Bond says 30,000 cash. The rule you're talking about, counsel, goes to when the when a case first comes into play, before before the defendant is arraigned. That's so that the person has a right to come forward and not necessarily be locked up. Has nothing to do once the case has been already activated, there's been hearings held on it, and then your client doesn't show up. That's just for your information. All right, that's it.
Yes, that's it, Judge. Yep.